I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. It is not uncommon for a lessee to enter into an equipment lease either expecting to sublease the equipment or at least keeping that as an option. These provisions are not unreasonable, and as I said, they're fairly common. However, anytime you have equipment that you're leasing to a lessee who is going to sublease the equipment out, it is likely to be treated by the courts the same as a lease to a rental company. In other words, that sublease can convert the equipment from being equipment for Uniform Commercial Code purposes to being inventory. Now at this point, let me note that as we discussed in another of the videos, the rules are a little different if you have a motor vehicle involved. The certificate of title law probably, in all but 4 states, trumps the Uniform Commercial Code on what we're about to discuss. Nevertheless, the fact that it is inventory can cause a lot of problems in dealing with the equipment in the event of a lessee bankruptcy, or in the event that the renter or sublessee determines it wants to buy the equipment from the lessee. One thing that we advise wherever a sublease is concerned is that the lessor approach its exposure on 2 bases. First, protect the equipment. The fact that equipment is inventory can mean that it is sold by the lessee if the lessee is in the ordinary course of business of selling the equipment. What is more important is that if the lessee goes bankrupt, or is in Chapter 11, that sublessee might be able to make payments into the bankruptcy court and retain possession of the equipment. If the sublease grants the sublessee a right of quiet enjoyment, that sublessee is very likely to say that as long as it continues to make rental payments, it should continue to be able to use the equipment. And it may be a long time before you can get your rental payments out of the bankruptcy court. The cure to this is for the sublease to be subject and subordinate to your rights as lessor. Now that can be done one of 2 ways. Sometimes it is possible to have the sublessee sign an acknowledgement recognizing your rights as lessor. That's the best way, but very often it's unpopular with lessees and sublessees. The alternative is to have the sublease itself contain an express statement that the sublessee's rights are subject and subordinate to those of the prime lessor. The second issue to be covered is that rent stream from the sublessee. If it is possible that that will be the better credit or the one that you're going to be relying on, then it is important that the sublease be assigned to you as additional collateral, and, if at all possible, that you have possession of the sole original counterpart of the sublease. That's because that sublease may well be treated as chattel paper for Uniform Commercial Code purposes. And if you don't have possession of it, then a competing creditor might be able to interrupt that rent stream and take it for itself. Whether you can get subject and subordinate agreement by the sublessee, whether you can get possession, physical possession of that sublease, is a matter that is negotiated from time to time on a case-by-case basis. For more information about this and other topics, please visit www.leaselawyer.com.